The focus of today's conference is going to be what opportunities do we have as a movement dedicated to preserving the dignity of all human life, including innocent unborn life. What opportunities does his presidency present to us? So throughout the course of the day, we're going to hear different speakers talk about what possibilities we have nationally, in the courts, at the U.S. Congress, what the situation is in the state of California, and we hope that you will all learn a lot today, because that's sort of the point. I think there's a lot of aspects of what the president can do that a lot of people don't realize he can do. So I'm going to be the leadoff guy for today, and so my talk is abortion law, myths and facts. In order to understand what President Trump can do, we have to kind of understand what the law surrounding abortion is in the United States currently. So my talk is basically just to give you a kind of basic primer, a basic understanding of how abortion law functions right now in the United States. Okay, so the first question, and this is a question that a lot of people ask, like, you know, I'm pro-life personally. I think abortion is wrong, but why do we need to have laws against it? Why do we need to be concerned with, you know, laws and public policy? Shouldn't we be more concerned with, you know, changing people's hearts and minds? And I certainly agree we have to change people's hearts and minds. But I also don't think that law is unimportant. Let me sort of explain why. If there's any purpose or role for government or for laws, and a lot of people have different big, profound philosophical disagreements about it, but one thing everyone can agree on is that government exists to protect you, to protect private persons from private violence. It protects private persons from private violence. Okay? If I look out in the crowd and I say, you, I'm going to run into this crowd and I'm going to beat you up. I'm going to punch you in the face. Well, what is there to stop me? Well, you know that you're authorized by law to defend yourself. Everyone in the room knows that they're authorized by law to defend this man against unjust aggression. Everyone knows that if there's a police officer in this room, he can pull a gun on me and tackle me to the ground. And that police officer could arrest me if I successfully punch somebody. And I could go to jail. And I could go have a trial, and I could be convicted of a crime, and I could go to jail. So you are protected from private persons engaging in violence against you by the courts, by the police, by laws giving, you know, laws that give you the right to defend yourself. And that's a really important aspect of civil society. That's a very important aspect of the laws. What we have for unborn children, though, is a different situation. For this entire segment of the human population, this is a population of living human beings for whom there is no protection against private violence. An abortion doctor goes towards a mother's womb. There's no police officer there to tackle him down. There's no right, you know, a pro-life person doesn't have the right to jump into the clinic and tackle the abortionist and stop him. The child can't defend themselves. So essentially, we have a whole segment of the population who have no protection from private violence. A state of affairs very similar to slaves in the South during the pre-Civil War era, similar to apartheid South Africa, similar to a lot of other, to the ghettoized situation of the Jews in Nazi Germany. So you have any time in human history where government has said, no, this segment of the human population we're not going to defend, it has led to horrific atrocities. And in our case, in the United States, it's led to 50 million unborn children aborted, and the limitless human potential that they represented completely wiped out. So that's why we need laws. You know, you might feel good if I could convince everyone in this room not to punch you in the face, you would feel good about that. But if, legally speaking, none of us would suffer any consequences from doing it, you're not going to be sitting too easy in your chair because you know I'm not protected. That's why we need laws. That's why we need to change the landscape of our laws surrounding abortion. So that's sort of a basis for when people say to you, I'm personally pro-life, but I don't know that I want to enforce my views on other people. Well, that doesn't make sense. If you think unborn children are living human beings deserving of protection, they need protection, and that protection comes from our laws. Okay? So Let's move on. So what's the reality of American abortion law? Abortion is legal for all 9 months of pregnancy in all 50 states. The states and the federal government mostly cannot regulate or abolish it for any period of time. America has some of the most permissive, liberal abortion laws in the world. Now, when I say that, there's a category of about 7 countries in the world, including the United States, China, North Korea, Vietnam, those exemplars of human rights, who allow abortion for all 9 months and for any reason. Okay, and that's an unusual combo. Most of the world bans abortion after 20 weeks of pregnancy. Much of the world bans abortion after the first trimester. Now, I'm not saying abortions before those time periods are morally acceptable, but it just sort of reflects how extreme America's abortion law is. And we have a number of Supreme Court decisions to blame for that. Raphael? So how did this happen? Well, it happened through basically the top 3 Supreme Court cases that are listed here. Roe v. Wade and Doe v. Bolton, which were released on the same day in 1973, and then Planned Parenthood v. Casey, which basically preserved what Roe and Doe initiated. I'll also be talking a little bit about Whole Women's Health v. Hellerstedt, which was a decision from last year, which sort of explains how the Supreme Court approaches abortion cases. Next. Okay, so a basic primer on how the Constitution and laws work. Is in order to understand how the Supreme Court has so much power over our abortion decisions. So the Constitution is kind of like America's super law. It embodies the most important structures and human rights and values that we hold dear as Americans. And as a result, it's really hard to change the Constitution. You need a constitutional amendment, and to get that, it's a very, very difficult process. You need 2/3 of the House and Senate. You need 3/4 of the states. It's a very difficult process to amend the Constitution. Now, let's contrast that with on the right. There's just a bill sitting on Capitol Hill. Laws like this are passed, thousands of them are passed every year at the U.S. Congress and in the State House in Sacramento. And it's very straightforward. Pass a bill in California, you need a majority of the Assembly, a majority of the state Senate, and the governor to sign off on it. The U.S. Congress, you need the House of Representatives, the Senate, and the President to sign it. So laws sort of come and go. They're for smaller issues, not these enormous issues. So laws have to be consistent with the Constitution, okay? If in Sacramento they passed a law that said, we're passing a law, no one's allowed to attend a Seventh-day Adventist church. So what would happen? Well, the Seventh-day Adventists would file a federal lawsuit. The federal judge would look at it, and he would say, yep, this is unconstitutional. It clearly violates the First Amendment. This law is null and void, and it can't be enforced. Okay? So laws have to be consistent with the Constitution. Now, the difficulty is that the Constitution isn't always exactly crystal clear about what it means. For example, the First Amendment just says the right to free speech shall not be abridged. Okay, but what if we're in a crowded theater and I yell fire? Is that speech that's protected by the First Amendment? What about pornography? Is that protected by the First Amendment? What about... Not everything in the First Amendment is immediately clear just from the text. There is a history and a context behind what the framers of the Constitution wrote that judges have to know about, learn about, read about, understand, and they have to apply that to modern-day situations. Now, the Supreme Court is sort of the last court to which you can appeal, whether you're starting in the state courts or starting in the federal courts. They ultimately make the final determination about this is what we think the Constitution means about this, this, and this. So as a result, if we pass a law, it has to be consistent with the Constitution, and it has to be consistent with what the Supreme Court says the Constitution means, okay? And ultimately, a Supreme Court decision has the same weight as the Constitution. If you don't agree with something the Supreme Court has said, you don't have a lot of options. Your options are either to amend the Constitution to force the Supreme Court to interpret things the way you want, or you got to wait for some Supreme Court justices to die or retire because they have a lifetime appointment. It's right there in the Constitution. You either wait for them to die or retire, and then you elect a president who will nominate justices who think more like you do. Okay? So before we really dig into this, I want to talk a little bit about the 14th Amendment. I realize this is a lot of primer stuff. So the 14th Amendment was passed right after the Civil War, and it was one of two amendments that the North forced the Southern states to ratify before they could come back into the Union. The 13th Amendment abolished slavery. The 14th Amendment basically says that no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And clearly the focus of this was to protect freed slaves following the Civil War, so that they wouldn't continue to be enslaved and that they would have equal protection under the laws. Okay? Now, what happened, though, was that in the 20th century, this segment of the 14th Amendment got basically expanded enormously to protect a whole bunch of constitutional rights that I would just say personally the framers of the 14th Amendment didn't really intend. In fact, I spent a whole semester of law school literally studying this sentence. So, next slide. Okay, so what was the situation before Roe v. Wade? How was abortion regulated? So at the time of the founding, there weren't many laws about abortion, but we had this sort of English common law tradition where judges would make decisions, and these decisions would be handed down and handed down and handed down in a system of precedent. There were a few cases where people would criminalize, I think doctors mostly, for engaging in abortions, but in the 18th century and the early 19th century, people didn't really know much about fetal development. So no one was really sure if abortion was like kind of advanced contraception or possibly killing a living human. No one was sure when life really began within the womb. But in the mid-19th century, this began to change. Sort of around the time of the Civil War, more scientists and doctors began to understand more about embryology, and they began to realize, oh no, this is a living human being from the moment of conception. When this happened, you saw a major shift in the way that state governments in the United States and religious bodies worldwide viewed abortion. Around the mid-19th century, around the time of the Civil War, you saw almost every single state in the Union outlawed abortion, except in the case to preserve a mother's life, for example, like an ectopic pregnancy. Even the Catholic Church. So the Catholic Church for a long time had, like everyone else, didn't really understand exactly scientifically when life began. So the Catholic Church wasn't sure, is this contraception? Is this murder? Like, how do we deal? In the 19th century, the Catholic Church definitively said, okay, the science is here. This is wrong. This is the killing of a living, innocent human being. And anyone who participates in abortion is subject to excommunication from the Catholic Church. And it's right around this same time period in the 19th century. So by the time we get to Roe, a few states like California and New York were beginning to liberalize their abortion laws, but for the most part, most of the country outlawed abortion, except in the case to preserve the mother's life. Okay, so now we come to Roe v. Wade itself. And essentially what Roe v. Wade said is that within the 14th Amendment's Due Process Clause, which I have at the bottom there, no state shall deprive any person of life, liberty, or property without due process of law, they said there is an unenumerated, implicit, fundamental right to privacy. Okay? And they sort of derived this right to privacy from the 14th Amendment, but also from like the 4th Amendment, which prevents unlawful searches and seizures, and a couple of other amendments of the Constitution. Now, I think you could formulate a kind of right to privacy, but to say this is a fundamental thing that is not explicitly stated is a bit of a stretch. Then they infer from this right to privacy another right, namely the right to abort a child, for a mother to abort a child. So they infer a right to privacy that is not there, and within that, they infer again a right to abort a child. But that's not all they infer. That's not all that's hidden mystically in the text of the 14th Amendment, a bill designed to protect freed slaves. Apparently, also hidden within the 14th Amendment was a whole trimester structure of when state governments could regulate abortion. So in the first trimester, apparently, the 14th Amendment magically said no state interference was allowed. The second trimester, you could do a little more stuff. And the third trimester, they said you can ban abortion unless the mother's health is involved. Next slide. Now, that word health is important. What does that mean? Why aren't we seeing more states ban third trimester abortions unless the mother's health is involved? The problem is with another case that was released the same day as Roe v. Wade, called Doe versus Bolton. So Roe v. Wade was a woman who was challenging Texas's abortion statute. Doe v. Bolton was a woman who was challenging Georgia's abortion statute. And Doe v. Bolton basically defined that health exception. And basically it said health is everything. Health can refer to psychological health. It can refer to familial health. And if you're wondering what the heck's familial health? Well, my family dynamic would be disrupted if I had this child, so therefore my health is implicated, so therefore I can have an abortion. Essentially, there is no pregnancy possible where health would not be implicated. So it's an exception that swallows the entire rule. And guess who decides whether health is implicated or not? The abortionist, the man who's, man or woman, whatever, who is financially interested in the abortion taking place. And there are abortionists who go on record saying every single pregnancy possible can drastically negatively affect a woman's health, and therefore I always think abortions are medically called for if a woman chooses. Okay. So, Roe v. Wade says you can only ban abortion if the Roe v. Wade says you cannot ban abortion when the mom's health is at risk. Doe says that health is always at risk. Therefore, the result of Roe v. Wade and Doe v. Bolton was that you can never regulate abortion, you can never limit abortion. And these are Supreme Court decisions that have the full weight of the Constitution behind them. So this means that state governments can't pass laws to say, well, maybe no abortions in the third trimester. Nuh-uh. You can't do that. It violates the Constitution. A federal judge would throw that out if you tried to pass that law. The federal government can't do anything. State governments can't do anything. So, you may be confused at this blur of how the Supreme Court was inferring all of these things that were magically in the text of the Constitution. What was really going on? And I used this lovely image to sort of demonstrate what the Supreme Court justices just wanted to get something done. They were just trying to accomplish a goal. Okay, they were liberal guys who saw, okay, well, New York is liberalizing abortion and California is liberalizing abortion. England had liberalized abortion recently. And this seems like it's important for women's rights to allow women to have reproductive freedom and to be able to walk away from a pregnancy if they want to so that they can continue with their lives and education. So therefore, we're just going to kind of fudge it, and we're going to say, well, there's kind of a right to privacy in the 14th Amendment, and that right's probably big enough to allow you to have an abortion, and we'll kind of structure it this way so states can feel like they can do stuff even though they can't really. And from the journals of the Supreme Court justices at the time, we actually do learn they did not actually think this was going to be a very important case in terms of the national reaction to it. They thought that maybe the Catholics would be a little mad, and that was it. But here we are, here you all are, some 43 years later at a conference learning about what an awful decision this was. So. And it's not just me who says that I understand, like, obviously you're getting one side of it when you're hearing from me. It's not just me who says, I am not the only one who says Roe v. Wade was a terrible decision. Essentially everyone agrees, even liberals agree, that Roe v. Wade was a terribly reasoned case. Like, even a lot of people who agree with the final outcome of legalized abortion, they agree this was, flimsy justifications were used and it was a bad decision. Okay, so let's fast forward now 19 years. We were in 1973, now we're in 1992. The landscape has changed. 8 of the 9 Supreme Court justices have been appointed by Republicans. The pro-life movement is thinking, all right, we're here. This is the moment. We're gonna overturn Roe v. Wade. So Bob Casey, one of the last really great pro-life Democrats, was the governor of Pennsylvania and passed a series of laws that were obviously in violation of Roe v. Wade, but were intended to challenge Roe v. Wade. So 24-hour waiting period before abortion, parental consent before a minor's abortion, consent from a husband for a wife's abortion. And this is what happened. This is a painting of one of the great betrayals in human history. This is Brutus stabbing Julius Caesar in the back. And this was basically put Justice Kennedy in the role of Brutus and put the pro-life movement in the role of Julius Caesar. So the court's final ruling was basically to maintain the outcome of Roe versus Wade, pretty much 99% of it, but allows some limited regulation of abortion, and we'll jump into that. So these are the three main culprits. This is David Souter on the left, Sandra Day O'Connor in the middle, and Anthony Kennedy on the right, all appointed by Republicans, all ruled to uphold legalized abortion for all 9 months. So abortion under Planned Parenthood versus Casey, and let me just say, Planned Parenthood versus Casey is really more important for us today than Roe v. Wade. It's sort of replaced Roe, and it's kind of the controlling abortion law to this day, okay? Essentially, they said abortion is now a protected liberty interest. That's kind of lawyer talk. It means it's not a fundamental right anymore. So if it's a protected liberty interest, other interests can compete with it. So basically, it allows some limited regulation of abortion. So states can now pass laws like requiring parental notification or consent before a minor can have an abortion. States can do health and safety regulations. They can pass 24-hour waiting periods. We were successfully able to outlaw partial birth abortion. But essentially, these are only small things. Justice Kennedy thought that the word liberty that was there in the 14th Amendment was a very broad and important term, and that it could encompass a woman's right to make private medical decisions for herself, including the right to have an abortion. So now this is the part where I make fun of Justice Kennedy, and like every know-it-all conservative law student in the United States, I'm going to make fun of him. So there was one part of the Planned Parenthood versus Casey decision that Justice Kennedy wrote, and this is the quote. "At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life." And Kennedy goes on to say, well, you know, we can never really know when life begins. It's this mystical thing. So it's between a woman and her doctor, and we're not going to intervene and say when we think life begins. But can we see sort of the ridiculousness of this? He is weighing in on when life begins or not by saying we're not going to give any legal protection to anyone who is not out of the womb. And he's very definitively made this radical decision excluding a whole segment of the human population from having the same rights and dignity that, say, a one-day-old newborn has. So it's actually and even more bizarre, the idea that individuals can define, as part of my individual conception of existence, I can define whether other people have human value or not. I mean, if that's true, I could run you over with a bread truck, and should I face any consequences? Maybe not, according to Kennedy's viewpoint. So he was trying, I guess, to be like a philosopher or something, and he's just completely incoherent. So Justice Kennedy thought that Planned Parenthood versus Casey would fix Roe v. Wade to allow a little more state regulation, and I think he fixed it about as well as this guy fixed this brick wall here with some Lego bricks. So again, he's inferring all of this stuff into the 14th Amendment that just isn't there, this time into the word liberty. And so basically, instead of the trimester system from Roe v. Wade, something that wasn't there, he's replaced it with this system about children who aren't viable and children who are viable. Again, totally not there in the Constitution. And also a weird standard, because viability depends more on like how good your NICU unit is than any internal qualities of the child. Viability is a standard that has moved earlier and earlier into pregnancies as technology has improved. So basically he says, before viability, states cannot unduly burden a woman's right to access abortion. So Kennedy thought that parental notification and consent laws and 24-hour waiting periods, those are not undue burdens. But having a husband sign off before his wife has an abortion, that was an undue burden. So Kennedy struck that law down. Now you may be saying, well, what is this undue burden thing? This was a question that Justice Scalia asked in his dissent in this case. What is an undue burden? Ultimately, whatever Justice Kennedy thinks it is. Because right now we had 4 pro-life justices, 4 rabidly pro-choice justices, and Kennedy. And if Kennedy thought that your abortion regulation was undue, he would strike it down as unlawful. If he thought it was okay, he would uphold it. So basically the Supreme Court has just become a big medical review board that tries to decide whether any abortion regulation has more benefits or burdens to it. So I'm wrapping up right now, and I just want to give sort of the landscape of where we stand right now when it comes to the Supreme Court. And that's a picture of the court prior to Justice Scalia's death. So right now there are 3 and soon to be 4 probably justices who are opposed to Roe and Casey and who don't think that the Constitution requires legalized abortion. Those are Justice Thomas, Chief Justice Roberts, Justice Alito, and Judge Gorsuch, who was just announced by Trump as his nominee to the Supreme Court. We'll be talking a bit more about Judge Gorsuch later today, but I think all signs point towards him being opposed to Roe and Casey. You have Justice Kennedy, who's in favor of Casey because he helped to write it. And then on the left, you have Breyer, Ginsburg, Kagan, and Sotomayor, none of whom really agree with Planned Parenthood versus Casey. Now, as I've said, Planned Parenthood versus Casey allowed some limited abortion regulation, and I don't want to diminish that. There are about 25 years now of pro-life laws that have been passed in states all over the country, parental notification laws, parental consent laws, waiting periods, health and safety regulations, all this different stuff that Casey allowed us to pass. The problem is that those 4 liberal justices there, they think if they were to get a majority, if they didn't have to listen to Justice Kennedy in order to gain a majority on the court, they would swipe away all of those laws. So this is the great risk that was at play during the last election. Had Hillary Clinton appointed a pro-choice person to the Supreme Court, you could have seen 25 years worth of pro-life laws completely swept away. And the thousands of lives that those laws have saved over the course of 25 years would be open to acts of private violence again. So that's part of the reason why this election was so important. You know, again, we don't endorse candidates or anything, but the stakes were really high on the pro-life front, and getting Judge Gorsuch on the court rather than someone else may be a really huge thing in the fight to end legalized abortion. So what's the future? It depends. I really like those pictures because it looks like Justice Ginsburg is just glaring at Donald Trump, and Kennedy is lecturing him. And it really does depend. Justice Ginsburg is 83 years old, and Justice Kennedy is 80 years old. There's some thought that Kennedy might resign. Who knows? I think Justice Ginsburg is going to hold on by her fingernails until Donald Trump is out of office. So we'll see. If either of them die or resign, or one of the other justices do, Donald Trump will have the chance to replace them over the next 4 years. And right now, basically, assuming Judge Gorsuch gets to the Supreme Court, our numbers are 5-4. Five judges in favor of legalized abortion for all 9 months of pregnancy, 4 judges who say states should be able to regulate this as they want. So those are the stakes, and that's kind of where we stand. So this is just kind of setting the table. And now we're going to switch to our next presenter, who will be